Morning, ladies and gentlemen. This is August 25th, 2025, 2025. I'm Judge Tammy Long Hayward. This is Clayton County State Court, courtroom 304. This is the jail and arraignment calendar. I'm going to call the calendars in a moment. I'm sorry for the delay, but Zoom, I don't know what they were on this morning because they were advertising and I couldn't get to sign in, and it's a lot. All right. So on the arraignment calendar, I'm going to call the calendar and the attorneys are going to speak on behalf of the clients. If they are represented, if they're not represented, then we'll talk directly to you and see how we can help you get through this calendar. Please remember to mute your devices until we're speaking with you. Please also remember to put your first and last name on the calendar, okay? All right, first case on the calendar is Rashid Afdal Rauf Akil.
Judge, I believe I saw Mr. Akil on the Zoom call, yes, down at the bottom. Mr. Akil, if you could please turn on your camera and unmute your microphone just so the judge can see that you're present. And Judge, I do believe I have an understanding of how Mr. Akil wants to proceed. However, I would just request a brief conference to make sure that he understands what's on the table and what the next steps are. So if we could just have a brief conference with him.
All right, Mr. Akil?
Yes, ma'am.
Okay, so we're gonna have a conference on in your case with your attorney. Just give me a minute to get through the calendar, and once I'm ready to set up the conference, you'll get a prompt to go into the breakout room, okay?
Okay, that's fine.
All right, just hold on for me.
All right.
Daquan Abeyu Bridges.
Yes, Judge. Ms. Tortorella, I believe, represents Mr. Bridges.
Yes, Your Honor. Mr. Bridges is on the Zoom call, and that would be a negotiated plea today.
All right. Okay, next is Samuel Cho.
No. I don't believe so. No, not at all.
Samuel Cho.
Yes, Your Honor, I'm here.
Mr. Cho, are you over 21?
Yes, I am.
Okay, good. All right. So, Mr. Cho, you're not represented by an attorney. If you wish to be represented by an attorney, I would appoint one of the ones that we have here in court today by video. You're charged with too close with an accident and no insurance. Now, it is possible that if you can provide proof of having insurance, that charge could be resolved differently.
I currently do not have insurance, so I don't have a vehicle. I work from home, so.
Okay. All right.
Yeah.
Did you wish to have an attorney represent you, or did you wish to represent yourself and speak directly with the state's attorney to see if they have a plea deal that you'd be willing to take to resolve this case?
I think I'll be more comfortable having an attorney if possible.
All right, Mr. Cho, I'm going to appoint the law firm of Lister Holt Dennis to speak with you.
Okay, thank you.
Okay, this is what I'm going to ask you to do. Do you know how to use the chat function?
I'm not really familiar with Zoom, but
okay. All right. So if you click on where you see your picture, you should see a blue box with 3 white dots. If you click on that pull down menu, do you chat in the pull down menu? I'm sorry, do you see the box with the 3 white dots?
I do.
I just sent a chat, Mr. Cho. If you can respond to that, that may be easier.
Yeah, so if if you see his chat, go ahead and respond with your first and last name, your email address, and your phone number where he can reach you today.
Okay, sounds good. Thank you.
All right, and then once you do that, you can go ahead and mute your device. Okay. All right, whoever is Ebony, whoever is iPhone, I need your first and last name on the calendar. So please rename yourselves. I need Ebony's first and last name. I need the iPhone designation, first and last name. Next on the calendar is George Carroll Dotson Jr.
Judge, Mr. Dotson is present in the courtroom. I'm having him come forward. Come to where I'm standing. So you can.
Mr. Dotson, I do not see an attorney for you, sir. Do you wish to work with an attorney or did you wish to represent yourself?
I'm just trying to represent myself.
Are you over 21?
Yes, ma'am.
All right, so sir, you're charged with speeding 21 to 25 miles per hour over the limit. Mr. Tipton, do you have a recommendation?
Didn't realize I was muted, Your Honor. For Mr. Dotson, it'll be a $200 fine plus court costs.
Just
All
$100.
right. So Mr. Dotson, if you wish to enter, is he NOLO eligible?
Yes, Your Honor.
So Mr. Dotson, you have some choices. So if you wish to enter a plea today, you are NOLO eligible. A NOLO can be used once every 5 years for the same or similar offense. You would be able to use your NOLO to avoid points on your license, as this is a moving violation and it is over the speed for which you can avoid points. So you would definitely, I think, get points for this violation if you enter a guilty plea. If you're not worried about points, then you can use your guilty plea. But if you wish to not have points on your license, you can use your NOLO plea, or you can enter a plea of not guilty and have it. What would you wish to do? The fine will be $100 if you enter a plea, and that's going to be $151.50. So that's the fine plus the state surcharges.
No.
Okay, so raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
Okay, you can put your hand down, Mr. Dotson. So, Mr. Dotson, you're before the court on 2023 CR 04511 for speeding 21 to 25 miles per hour over the limit. You're entering a plea of NOLO. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right. Factual basis?
Yes, Your Honor. Your Honor, on February 6th of 2023, officers with the Georgia State Patrol observed a black Chevrolet Camaro driving down the roadways of SR 85 near Allen Road in Riverdale, here within the boundaries of Clayton County. The road was clearly marked for 45 miles per hour, but the defendant was clocked using a LiDAR doing 66 and a 45.
All right. So, sir, you've entered a plea of NOLO. The fine is going to be $100. That'll be $151.50 with the surcharges. Did you wish to pay that today or have additional time?
Oh, I want to pay it today.
I'm sorry?
I want to pay it today.
Okay, so when you leave the courtroom, you're going to go down to the second floor. So you're going to go down one level, come back into the hallway. And when you come back into the hallway, go to your left and you'll see the traffic court window. You can pay there and they'll give you your paperwork, okay?
And that's it. I can go.
Yeah, once you pay, you go.
Okay. Thank
All right. Thank you. Slow down for me, sir. Be safe.
you. That's it.
Yeah, just head to the second floor for me.
Thank you.
All right. Lateef Shaboluju. Lateef Shaboluju.
Judge, it's been reset till September 16th.
Okay, I didn't see a waiver, so, all right. All right, next is Candace Jeanette Smith. Candace Jeanette Smith, Mr. Holt Dennis.
Judge, I believe Ms. Smith is present on this. Turn on your. Judge, I believe we
right.
continued this case for Ms. Smith to get her license. I'm hoping that she has. If we could just have a conference with Ms. Smith to see whether that's happened and how she's going to proceed in either case.
All right, so conference with Ms. Smith. All right, next is Shamar Thorpe.
Your Honor, Mr. Thorpe should be on the Zoom call. He is, I need to conference with the state on his case. And I just want to go back to Mr. Bridges, Your Honor. I did misspeak. I would need to conference with the state, but it definitely will be resolved today.
All right. LaShondra Arlesia Turner. Turner.
Your Honor, I think I see her on Zoom. I don't know why she's not responding.
Ms.
Oh,
Turner.
I'm here. I thought the guy was gonna speak, the attorney from Lister and Holt.
Okay. Mr. Lynch, I don't see you all listed, but she says that she has you, so that's fine.
It's possible we were appointed in the.
Yeah, y'all were you appointed him during my last court date
Okay.
back in June.
All right, so somehow it didn't make the calendar, but that's fine. We're good. Mr. Lynch.
If we could just have a conference, I believe there was some discussion of a resolution for today, but if I could just have a conference with her in the state, I think we can get on the same page.
All right, so what I'm going to do is go ahead and set up the conferences before we go to the jail calendar. So we need a conference on Akil, Bridges, Mr. Cho has been appointed, then Smith, Thorpe, and Turner. So whose computer am I setting up?
My computer with ASG Tipton. I need to speak with him first.
And I'll start by speaking to Mr. Cho, and then I'll see where we're at with breakout rooms.
All right, so breakout room number 1 is going to be Mr. Tipton and Ms. Tortorello.
And Your Honor, while that's going on.
Hold on just a second. Ms. Tortorella, I don't see your device.
I'm going to log on right now, Your Honor.
All right. And what were you saying, Mr. Tipton?
Your Honor, while that's going on, I know we have several private attorneys here. Could they be placed in the courtroom so that they may speak to their clients?
Sure. Okay. So who needs to speak to the clients?
Because I know I just negotiated something with Mr. Wallace, and I'm not sure if Mr. Middleton needs to speak to his client.
All right, these are jail clients?
That's correct, Your Honor. Mike Wallace speaking. My client is in custody, but I've already had discussions with him, but I won't need to just talk to him before the court.
Okay, so let me go ahead and clear the arraignment conferences, because they, if we can get them to all talking to Mr. Tipton and moving forward, then we can go straight to jail and not have to come back to arraignment.
Your Honor,
Yes.
Attorney Middleton here.
All right.
Really, I don't need to speak with my client. However, we are waiting.
Okay. Mr. Walker is present in the courtroom?
Oh, yes, Mr. Walker. Yes, she is present, Your Honor.
All right. Ms. Tortorello?
I'm on the call, Your Honor.
All right, so let's see. All right, Ms. Tortorella and Mr. Tipton are breakout room number 1. Mr. Lynch is speaking with he wants to speak with Mr. Cho in the courtroom. Let me go ahead and put Mr. Cho and Mr. Tipton in breakout room number 3. I mean, Mr. Cho and Mr. Lynch in breakout room number 3. Mr. Cho, you're going to see an invitation pop up on your screen. Go ahead into the breakout room. If you want to get out of the breakout room, just activate your screen again, and you should see leave breakout room or return to main room. I'm going to put you in breakout room number 3, and the courtroom is going to come into breakout room number 3. All right, so the breakout rooms are set up. As soon as you all give me a heads up that you have finished speaking, then we can go ahead and run through the arraignment calendar very quickly.
You're on, if I may, please,
I'm sorry, go ahead.
may I please be placed in a breakout room with Mr. Daquan Bridges?
Yes.
Thank you.
Your Honor, I'm going to move my base of operations down to the courtroom. I may be unable to respond for about 5 minutes.
All right, no problem. All right, Mr. Tortorello, Mr. Bridges, you're in breakout room number 4. Mr. Cho is still in breakout room number 3. Mr. Lynch.
Your Honor, Byron Morgan, could you please put me in a breakout room with the jail? I need to talk to my client.
Okay, we don't have a breakout room with the jail. We just have the courtroom, and the individuals aren't up yet. I
Okay,
mean, they're up, but they're behind the doors.
I understand, Judge. Thank you.
And Your Honor, I'll hold off on going down to the courtroom until Mr. Morgan speaks to his client to allow for the most confidentiality that I can.
Well, I don't know that they're up and out because there are people in the courtroom, so they haven't been pulled out into the courtroom yet.
Oh, I understand. Thank you, Your Honor.
Your Honor, I just wanted to announce that I have spoken to Mr. Cho about his case, and we are ready to enter into a negotiated plea to resolve that. If Mr. Tipton's ready, or I can move on to the next conference.
Whenever Mr. Tipton gets down there, I'll be fine with that.
Okay. Yes.
Are we ready in the courtroom? Is Mr. Tipton there?
Yes, Your Honor, Mr. Tipton's here, and I do have an announcement on behalf of Mr. Bridges. And
I'm
we are,
ready.
we
Let me
are
know.
ready. Yes, Your Honor, we are ready to move forward with a negotiated plea.
Okay, I'm ready on Bridges. Do we have any other announcements?
And nothing else on behalf of defense, Your Honor.
All right, Mr. Bridges, unmute for me. Let me see you.
Yeah, how you doing?
All right, raise your right hand for me, sir. Oh, wait, where's Mr. Tipton? Oh, there you are. Raise your right hand. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, so sir, you're before the court on State of Georgia versus Daquan Aveyu Bridges, 2022 CR 00630 for DUI less safe, count 1, improper lane change, count 2, seatbelt violation, count 3, and no license, count 4. Ms. Tortorella, what is your client plea to the offenses before the court?
Your Honor, for DUI, it would be a guilty plea. For seatbelt violation, a NOLO plea, and my understanding is that the state is no crossing the remainder.
All right, so a guilty on count 1, NOLO on count 3, counts 2 and 4 will be no cost. By entering these pleas, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On October 25th of 2025, officers with the Clayton County Police Department responded to an incident on the roadways of Clayton County where they observed the defendant failing to maintain his lane. The defendant, upon making contact with the defendant, they observed they had bloodshot, watery eyes and slurred speech. They field sobriety tests, leading 6 clues on HGN, 2 out of 8 clues on walk and turn, and based off of that, they arrested him for DUI less safe, determining he was a less safe driver. He was also driving without a seatbelt securely fastened. State's recommendation, Your Honor, is for count 1, 12 months to serve 2 days, credit for time served, $300 fine, balance probated, 40 hours of community service, substance abuse evaluation, any recommended treatment, no drugs or alcohol, subject to random testing, DUI risk reduction course. Count 2 will be dismissed per plea negotiations. Count 3 will be a suspended fine of $15, and count 4 will be dismissed per plea negotiations.
All right, Ms. Tortorella, anything on behalf of Mr. Bridges?
Just that you accept the plea as negotiated, Your Honor.
Mr. Bridges?
Ma'am.
I know this was a while ago. You put your hand down, sir.
Oh,
I know this was a while ago, but I hope that you have learned from this situation. We got too many things, too many alternatives. We got Lyft, we got Uber, we got things I didn't have when I was your age. And so you have alternatives to operating a motor vehicle with under the influence, because you could kill yourself, you could kill somebody else. There was nothing that I could sentence you to that would be worse than waking up every day knowing that you took away somebody's loved one out of carelessness, recklessness, foolishness. You understand?
yes, ma'am.
Okay. So I'm going to accept your plea of guilty to count 1, no low to count 2, to 3. I'm sorry, counts 2 and 4 will be no prost. And I'll sentence you on count 1 to 12 months to serve 2 days, credit for time served. The balance will be probated for you to pay a fine in the amount of $300. That's going to be a pretty hefty fine because for DUI, the surcharges are elevated. I can't tell you exactly what it is because I haven't memorized it and I don't have my sheet in front of me, but it's going to be prepare to pay probably $600-700 for that. 40 hours of community service, a substance abuse evaluation, and any treatment that they might order. You're to have no alcohol or drugs during the course of your probation. You're subject to random screens for drugs and alcohol. And you're also to do a risk reduction course. On count 3, that will run concurrent with count 1. It's a $15 fine, but that fine is going to be suspended. So you don't have to pay that. You do have to complete all of the court's ordered conditions for count 1. Now, let me just let you in on something. For some reason, people think that we won't test. We will. For some reason, people think that you won't get caught. You will. And here's the other thing. Think about this. If I'm telling you to not use drugs or alcohol during the course of your 12 months probation, or else you could end up back in jail. If you're willing to risk jail, being away from your job, being away from your family, being away from your home, being in the Clayton County Jail, which I'm hearing is not a pleasant place to be right now. If you're willing to risk all of that for a drink or for a puff, that means you got a problem. Because if somebody told me to not do something that I didn't need to do for 12 months and I could stay out of jail, I wouldn't be going back to jail. But if you're willing to risk it and you know you could end up in jail, then that tells me that there's a deeper problem and we may need to have some counseling for that. We clear?
Yes, ma'am.
I keep getting people who tell me they don't have a problem, but they ended up back in front of me because they were willing to risk going to jail to have a drink or to have some cocaine or to have some marijuana. I just want you to think about that every day that you're out, those friends you hang with and they're doing stuff and they're like, man, you know, you're not going to get caught. You will. All righty. So what I'm going to do now is I'm going to put you in a breakout room. You're going to be in a breakout room with Miss James. Miss James is our probation expert. She's going to talk to you about probation. She's going to explain everything you need to know. If there are questions that you need to ask her about anything happening in probation, you go ahead and ask her those questions. Let me just explain. The quickest way to get rearrested is to not go to your probation reports. I need you to report to probation. Now, if there's something you're having difficulty with, please tell your probation officer because they're here to help you successfully complete probation. But if you don't go to your probation reports, you definitely will end up back in front of me. Do you understand?
Yes, ma'am.
All right. So I'm going to put you in the breakout room with Miss James. Get signed up for probation. You do not have to come back to this main room. You're free to go after that, but just please make sure you go ahead and finish what you need to do for probation, okay?
Yes, ma'am.
All right, Mr. Bridges, thank you.
You're welcome.
All right, take care. All right, next. You said Mr. Cho, Mr. Lynch?
Let me get Mr. Lynch, Your Honor.
I apologize, Judge. I was speaking of.
Mr. Cho, you ready?
Yes, ma'am, I am.
All right. So this is Mr. Samuel Cho. Mr. Cho is represented by Lester Holton Dennis, Mr. Lynch, case 2022-CR01449. Mr. Cho is charged with too close with an accident. count one, no insurance, count two. Mr. Cho, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand out. Mr. Lynch, what is your client plead to the offenses before the court?
Judge, he's asking the court to accept a plea of injury to both counts, no insurance and close.
All right, so by entering a plea of nolo to counts 1 and 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Cho?
I do, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. On April 2nd of 2022, officers with the Clayton County Police Department responded to an automobile accident at the intersection of I-675 near Forest Parkway. It was determined that the driver, who was the defendant before you, Samuel Cho, did follow closer than was reasonable, and in doing so, hit the back of the driver in front of his car, and he was driving without valid insurance. State's recommendation, Your Honor, for count 1 is a $100 fine. For count 2 is a $200 fine.
All right, Mr. Cho, I'm going to accept your plea of nolo to counts 1 and 2. I'll sentence you on count 1 to pay a fine in the amount of $100. That's going to be $151.50 with the surcharges. On count 2, it's a $200 fine. It'll be $298 total with the surcharges. And did you wish to pay those within 30 days or 60 days?
Within 30 days.
All right. Now, you have several options. You can come into the Clayton County State Court and you can pay on the second floor at the window. You could also pay online or by phone. What I need you to do is to chat your email address to Miss Wright. And then she's going to send you your sentencing sheet by email. It's going to have the date by which you need to pay. It's going to have the information about paying online or by phone. And then you can always have the option of coming in at 9151 Terra Boulevard and paying there. Okay?
Okay.
All right.
His email to Ms. Wright
Oh,
already.
okay. So Mr. Lynch has already sent your email. Please check your emails. If you don't see it within the next day or so, check your spam folder, but it should be from the Clayton County Clerk's office, okay?
Okay. Thank
All
you
right,
so
now,
much.
Mr. Cho, insurance is important because you never want to be in a situation where you have an accident with somebody and you're unable to make things right for them, okay? I have seen people, if they can't get their car repaired, I've seen them lose their job and their housing. And so you don't want to be the cause of that kind of catastrophic event in someone's life, okay?
All right. I
All right,
understand.
take care. Thank you,
Thank
sir.
you.
Okay, still on the arraignment calendar, we have Akil, Smith, Thorpe, and Turner. What we doing?
Judge, Ms. Turner is going to do a negotiated plea. I do need to just very briefly call her one more time, make sure she understands the rights, but we can do that momentarily. And then I'm not sure if Ms. Tortorella has any announcements.
I do have an announcement, Your Honor, on behalf of Mr. Thorpe. I do need to convey to him the offer that the state has just provided me with, so I would need to be placed in a breakout room with Mr. Thorpe.
All right. I'm putting Ms. Tortorella's device in a breakout room with Mr. Jamar Thorpe. All right, Ms. Tortorella, you're in breakout room number 4. Mr. Thorpe, I'm putting you in breakout room number 4. All right, Mr. Tipton.
Yes, Your Honor.
Are you ready on the motion to revoke for Mr. Walker?
I am, Your Honor.
All right, Mr. Middleton, are you ready on the motion to revoke for Mr. Walker?
Can you hear me, Your Honor?
I hear you.
Okay.
All right, where's Mr. Walker?
Ms. Walker is present in the courtroom.
He's on the way, Your Honor.
All right.
Your Honor, may I say something before we get started?
Okay. Go ahead, sir.
Okay. If you can recall, Mr. Walker has submitted a application to Cobb County.
And he was rejected. Yeah, I recall.
Now, they said they said that he did not need treatment. Now, I don't quite understand what that means, that he doesn't need treatment.
I don't know what their metrics are, sir. So I don't know what they're measuring, how they're measuring, or what their baseline requirements are for their court. Because I don't deal with Cobb County, but you all requested that he be allowed to petition Cobb County to see if they could put him in drug court. If they have rejected him as not meeting the standards that they have, then it's back in our court.
No, they didn't reject him. They just said that he does not need any type of treatment. And I
So they were gonna let him go through the program, but he didn't need treatment, or they said that he didn't need to be in the program?
No, they did not say that.
Okay, well, sir, that's the way you made it sound to me. So
I made it sound.
I asked what the next option was, and we put it back on the calendar. This is all semantics to me. If he's not gonna be in the Cobb County program, then he needs to be here before me, and we need to move the case.
Yeah, well, I agree with you.
So I don't care what Cobb says, it depends on what we say.
Okay. However, Your Honor, if you can recall, we had a contract with the state back in what's that? November 13th of 21 at 5:14, where that made us an offer. We never rejected that offer.
Sir, that's not what we're here for. We're here for a motion to revoke.
I understand. I'm just bringing some things.
Because you didn't accept the offer before the motion to revoke was filed. So right now, what's before me is the motion to revoke, which, for the record, has been postponed from May 13, 20, I'm sorry, it was filed, it was continued from May 13, 2025, June 30th, 2025, July 29th, 2025, August 5th, 2025, August 19th, 2025. 5 times the motion to revoke has been moved because of a request from counsel. So let's get on the road.
Well, I hate to say anything else and we move on, but however, we filed appropriately our motions, and this thing was filed in April 25th, I believe. I can't see too good there. Of 25, is that correct?
I believe so, sir.
Okay. However, Your Honor, we must state before we get any farther that we did accept the offer from the state. And when we attended a hearing, we said so. And for the record, now we deem that as being a contract between the state and ourselves.
No, there was no acceptance because there was a novation of the contract. The novation was, we wish to participate in Cobb County's program. Give us the opportunity to see if Cobb County will accept him. So there was an offer made, but there was no acceptance of the offer made by Mr. Tipton or the state, because your novation was, let's do it in Cobb. So we gave you the opportunity to explore whether Cobb would accept him. They did, in fact, not accept him. There was no offer and acceptance under classic contract law. What you did was issue a novation. They didn't, Mr. Tipton's office has not accepted the novation because Cobb did not approve Mr. Walker for their program. Now, can we get to the motion to revoke?
We can proceed, Your Honor, but however, we would like to preserve our rights to appeal this.
Oh, you have every right to appeal. I never keep somebody from appealing, because
Yeah.
I believe in the constitutions of the state of Georgia and the Constitution of the United States.
Okay.
So you can appeal whatever you want to. We haven't even started the hearing.
Right. Okay, Your Honor, we're prepared to move
This is
forward.
case 2021 CR 08227, Willard Kirkland Walker. A motion to revoke bond was filed in this case. This is for Mr. Walker is charged with DUI less safe and striking a fixed object. He's represented by attorney Nathaniel J. Middleton, who's present. Mr. Tipton is representing the state. Mr. Walker, if I can ask you to move to the side or sit at table until such time as you are needed. You have the right to remain silent. You cannot be compelled to make any statements in this case or threatened in any way to make statements. But if you and your attorney have discussed it at the appropriate time, if you wish to give testimony, I will go over your rights with you, and then you can make a statement or testimony at that time. All right, Mr. Tipton, your motion.
Yes, Your Honor, and I am trying to get my chief investigator in here as he did some investigation on this case. But in the meantime, Your Honor, I would like to draw to the court's attention the motion itself that was filed. And in that motion, I want to bring it to the court's attention that State's Exhibit A is a certified copy of the bond conditions, which include a condition that the defendant not violate the laws of the state of Georgia. And I'd also like to bring the court's attention to Exhibit B, which is a certified copy of a conviction from Rockdale Superior Court. That is a that's a certified conviction from a DUI that is alleged to have occurred after the incident. Finally, Your Honor, with State's Exhibit B, we also included the sentencing sheet and the initial ticket that was cited by Rockdale that took place on April 4th of 2024. The bond conditions were placed on May 23rd of 2020. And this did result in a conviction. Ask those be admitted as State's Exhibit A and B respectively under judicial notice and self-authenticating documents.
All right, Mr. Middleton.
Your Honor, we are not disagreeing with the days in which these events happened. However, the 2020, we must say that it's been over 5 years today. This is August of 25, and he did receive a second, and we admit to that, DUI within the 5 years. But and he also was granted a bond by the magistrate court judge in which he served under that bond, and he has complied, other than he did receive another ticket.
Okay, so Mr. Middleton, the problem is, while the bond condition that you not get a violation of the laws of the state seems like a throwaway condition. Yeah, I'm on bond, don't do anything else that brings you before a court. Mr. Walker was on bond for a DUI, and it was during COVID, so things slowed down for us. He then goes out and gets another DUI in a different jurisdiction and was adjudicated for that. The problem that I have with this is that Mr. Walker has a chronic alcohol condition, but he won't sit at home and drink and stay home. He gets on the road. If you're already aware that you have a DUI pending, you're on a bond condition for a DUI, and you know that, if I'm not mistaken, he's had a previous DUI sometime in the past. Now, I could be wrong. If I'm wrong, correct me, but I don't think I am. But you don't take the responsibility to understand that you have a previous DUI, you're currently under a bond condition for a DUI, and then you go out and get another DUI. It's not like if you were telling me he got a speeding ticket, I'd be like, Mr. Tipton, this is not necessary. He got a speeding ticket. He got a window tint violation. But the difference is a motion to revoke bond is brought most often to make sure that there's protection for anyone who might be at risk from the actions of the individual. Mr. Walker is a chronic DUI driver. He drives while he is under the influence of alcohol. That is a risk to everybody on the road, including himself. Mr. Walker has tried to avoid the consequences of going to jail for it. But this is the problem. If you're already on bond for a DUI and you don't have enough restraint because you are an alcoholic and you go out and get another DUI, if he was drinking in his house and didn't move, I would never know about this because he would never have broken the laws of the state of Georgia. But he has so little restraint because of his condition of being an alcoholic and addicted to alcohol. But then you tell me Cobb County says he doesn't need treatment. Well, like I said, I don't know what their metrics are. But if anybody needs treatment, I would believe it would be Mr. Walker.
Can I say something, Your Honor?
Sure.
Well, Your Honor, Mr. Walker has been very remorseful of what the situation that happened way back in 21. But however, Your Honor, this is 25. And the requirements that the state gives for his revoking his bond, we question it. They're saying that he would flee the jurisdiction. Mr. Walker has attended all court proceedings and never tried to flee any jurisdiction. He's been here, he's come when I was not there, when I was ill and could not make court.
Mr. Middleton, that's not the reason that Mr. Walker, that the state has brought a motion to revoke bond.
Well, I'm looking at the motion.
He's a danger to everybody.
Okay, I hadn't got to that one yet.
Okay, well, let's get to that one because that's the one that concerns me.
Okay.
We don't want to waste my time on surplusage. The stuff that doesn't matter to me, he's to flee. He's been here every time. I will acknowledge that. But he's a danger to himself and others.
Your Honor, we admit that he did violate the bond order. And that's because of the dates. You can look at the date and see he did in the time period before he received another charge.
And we would have adjudicated this a lot closer to the time that it was brought, except we had to reschedule it 5 times.
Well, I understand, Courtney. We apologize for having gotten sick. But
I'm not asking you to apologize, but if you're going to make a timing statement, then it's not the timing, it's the fact that it was brought as quickly, this was brought in April. He got a certified conviction April 4th, 2024. This was brought this year and earlier this year, so we could have adjudicated it earlier, but it doesn't change the fact that what I'm concerned about is Mr. Walker being a danger to himself and others. And then when you come in and you say, well, Cobb doesn't feel like he needs any treatment. Well, I beg to differ. I'm not sure why they would believe that because I don't know what they're measuring.
Well, Your Honor,
are you going to tell me that Mr. Walker is not a danger to himself and others?
Well, Your Honor, he's my client. Obviously, I'm on his side. But however, Cobb County did issue that to us when we applied to the program, and we had, and if Your Honor, she can recall, you did accept him if he could get into a program, and I did, and we've done everything we could. So now we're back in this court's arm. Now, is it that this court rejects accepting him in that program? I haven't seen that yet.
Well, you didn't ask, and A, you didn't ask. B, what you asked for was to go to Cobb. Cobb rejected him. You keep saying they didn't reject him. They just said he didn't need treatment. It's semantics to me. the whole point is that now we have brought the motion to revoke bond, and now all of a sudden he's willing to accept what we could have done months ago.
Mhm.
Because if he can't go in a program in Cobb, it's either gonna be jail or a program. I'm gonna tell you right now.
We want a program, Your Honor. We said that.
Well, if he's not doing Cobb, it's gonna be jail or a program, but right now, that's not where we are. We're on the motion to revoke.
Well, I think what had happened though, Your Honor, you had sent this to another judge. I can't remember who you sent this to.
For the DUI program. And then you all said you wanted Cobb.
Well,
I sent you to the Clayton County DUI judge. You all said we would like to try for the Cobb program. I said, fine. Judge Garrett said, fine. You've driven this. We're doing what you're asking for.
Well, I beg Your Honor's pardon, but we were told that it would be most conducive if we were to apply for Cobb because he is a resident of Cobb.
Okay. But we're back here. Let's talk about the motion to revoke.
Well, as we're stating before, we don't disagree with the events that occurred, and that speaks for itself. However, and Your Honor's main concern is whether or not he will be a danger to himself and the community. I think that's what I hear Your Honor saying.
Yes.
Okay, and I'm saying to Your Honor, at this time, we are willing to, and we have participated. He's a member of AAA now, and I sent you some additional things which he's completed since he was arrested, being proactive towards resolving everything. We've taken 240 hours of community service. He's done the evaluation. He's taken the DUI, and we sent that over to you again if you had not seen it. And I'm not saying we're going to hang him today, but he is doing everything within his powers, and he's not received any tickets or anything in the past, 4 years. So,
Except for the DUI.
right, and that was in 21. Say, but he's doing everything, Your Honor, and in fact, he has a job now. He's become a very stable man. He was going through a divorce at the time, and job, he laid off his job, and I'm not asking for sympathy in that sense, but
You won't get any.
but he has not committed any act involving alcohol and the use of alcohol. And we're just asking that he give an opportunity to participate in that program and not revoke him. Although I know the Your Honor, we don't even want a trial, so we're just saying that we accept the burden that we have, and we're asking the court to have mercy on us and allow us to proceed.
Mr. Tipton?
Your Honor, at this point, is the court going to take judicial notice of the documents?
The court shall.
Thank you, Your Honor. At this time, I'd like to excuse Chief Henderson since we won't need him to lay a foundation.
All right.
All right.
I didn't hear the last thing you said, Your Honor.
At this point, I'm asking to excuse my chief investigator who obtained the documents because the court is taking judicial notice.
Oh, okay.
That's fine.
Your Honor, at this point, what we have is a contradiction, and the contradiction is that Mr. Middleton's telling us that Mr. Walker hasn't touched alcohol, but we've also got a conviction where he said that he touched alcohol and drove. We're hearing that Mr. Walker was not accepted into the DUI court program. Now, I'm the DUI court prosecutor in Clayton County. I'm familiar with entries into DUI court. I'm familiar with the fact that the main test that they use, the RANT, that's the risk assessment needs test, is highly dependent, incredibly dependent on the answers given by. I'm not saying Mr. Walker wasn't 100% honest, but what I would say is that
if he wasn't forthcoming with the number of DUIs, if he wasn't forthcoming with the issues he's had, if he wasn't forthcoming with why he saw it necessary to go through AA, then that may not have given them an accurate result. And in all fairness, it can be embarrassing to be that forthcoming. But that doesn't change the fact that Mr. Walker is a threat to the community. I don't think he's an intentional threat to the community. I think he's a negligent threat to the community. I think that he is being reckless in how he consumes alcohol. I think that he has been reckless enough to where he's gotten a new conviction, which the defense agrees with. There's no contesting the nature, the events that occurred after the bond happened. There's no contesting that Mr. Walker was arrested for DUI. And there's no contesting that it was so serious that they initially sought to put him in a treatment court. Your Honor, this is perhaps the most cut and dry motion to revoke bond I think I've ever seen. And, you know, once again, I'm not doing this out of any malice to, the state's not doing this out of any malice towards Mr. Walker, but we are doing it out of concern for the citizens of Clayton County. Because as Your Honor has stated numerous times, the worst thing that Mr. Walker could do is hurt or kill someone. And he'd have to live with that every day of his life. At this point, Your Honor, the state's going to ask that Mr. Walker have his bond revoked, that he be kept in the Clayton County Jail without bond until such time as he can be heard or he enters a plea to the DUI. With that, Your Honor, the state respectfully requests that the court accept, that the court grant the state's motion for bond revocation. Thank you.
Let me ask you one more question, Mr. Tipton. Since I don't have access to his GCIC, how many previous DUIs? What's this for lifetime for him?
If I may, Your Honor, if I may have a moment, Your Honor.
You may.
Your Honor, might say something in the meantime.
Sure.
We have here, and I don't know how much experience the prosecutors had over at Cobb County. I have the application here, and we sent a copy to Ms. Ponder of everything. And we even sent her where they said he does not need evaluation. But that's not the argument here. The argument is we feel as if Mr. Walker is somewhat being penalized for having, for Cobra having happened and all the time in between up until now. There's a lot of cases, Your Honor, still lagging. But that's not to say that he was not there. He's attended every hearing, we filed everything, we stood before the court, and we have said that we accept the plea. We accept the charges, and we get the contract with the court, and we have no problem with you going ahead right now and adjudicating it. I don't see where putting him, revoking his bond would make any sense at this time.
Your Honor, I have that GCIC, if I may.
You may.
Thank you, Your Honor. Your Honor, cycle 3 of his GCIC is a conviction for DUI out of Douglas County State Court. That is out of 2018. Cycle 5 is the Clayton County case that's pending. That's out of 2020. Cycle 6 is the Rockdale County case that he has pled to. That is 2021. And Your Honor, once defense counsel has completed their argument, I would like to rebut.
I'm sorry, say that again. He did what now?
Once counsel has completed their argument, I believe the state has a second closing to rebut, because I believe that I believe we're in the argument stage now.
Okay.
Your Honor, we can't hear you.
Oh, I'm sorry. I have a question.
Yes, Your Honor.
So I see Alliance of DeKalb County, Inc. is where he did his 240 hours of community service.
That is correct, Your Honor.
Except when I look at it on Google Maps, it's a park. It's Flat Shoals Park. 4522 Flat Shoals Parkway, it's a park.
Your Honor, I can answer that.
I'm sure you can. I'm looking at a park with children's equipment, but it says in the letter that you filed documents, bought supplies, you visited properties and other activities as directed.
Yeah,
What's that?
The Alliance of DeKalb County was a nonprofit organization. Its office was 4522 Flat Shoals Parkway. So it was actually office in the community center that's located at that location. There's a tennis court and a small park behind it, but the office was actually at that location. So it is a standing building. It's the Community Achievement Center.
Okay, so I have the Alliance of DeKalb County was administratively dissolved in 2022. I don't have a Myron Gooding associated with it. There's no website. It was incorporated by someone named Walker, Kirk Walker. So that doesn't exist, Mr. Walker.
It doesn't exist at this time, Your Honor.
Who is W. Kirk Walker? That's you.
That was me, Your Honor. Yes, I'm the original executive director. In 2019, I left the organization. So when all
Yeah, but sir, the organization was I'm on the Secretary of State's board. You can't give yourself 240 hours of community service. All right, that's it.
Ma'am, Your Honor, I was not working there at that time.
Sir, it doesn't exist. I don't see anything. I don't see a website. I don't see anything with Myron Gooding except that he's a mortgage professional. I don't see anything connecting this to the address for this is 21007 North Decatur Road, Suite 316. Everything else I got is the park. I was born at night, but last night.
Your Honor, nobody's trying to pull anything over your eyes. The organization, when I called.
Why would you go to a place that you incorporated to get your community service when there's so many other organizations out here where you can do community service? Why would you go to a place that I would even question? It's not even active, which means it is not a valid nonprofit because it does not hold a valid place. It is administratively dissolved, which means that that letter ain't worth the ink that's printed on it.
Your Honor, if I may, at that time, I was advised to do the community service by my attorney for this case.
Yeah,
I was not aware that it was
service, but you didn't look around for some place that actually needed community service. What filings are you doing for a nonprofit that doesn't exist?
At that time, the nonprofit, to my knowledge, it was existing. The work that I did was to make sure that the files were in place for the houses that the nonprofit had bought.
This was April 28th of 2022 that you gave me this letter. First of all, it is now 2025. So you want me to go back to an organization that you were associated with and give you credit from 2022 for 240 hours of community service? No, sir, not.
Okay.
Why are y'all even giving me this foolishness?
Well, Your Honor, you can reject that. I understand.
It is rejected.
Yeah, I understand Your Honor's logic in that. But with regards to the other things that we provided to you.
This is stuff he did for his other DUI. All of this is 2022. None of this is current.
Well, if Your Honor,
and if it had worked then, he wouldn't have had the DUI that he was convicted of.
We understand, Your Honor, so we will do the requirements in another program. Now, let's put it that way, since you've rejected those that he's done. Mm-hmm. Okay, we're fine with that.
Did you have a closing, Mr. Middleton?
Well, in closing, Your Honor, we said we'd like to get the mercy of the court in the sense that we have been actively trying to get the things done. And as we stated before, we accepted the first offer from the state as a contract, and we were in the process of.
I've already told you, the first offer was for the DUI court here in Clayton County. Well, your novation was for the DUI court in Cobb County. Therefore, there was no offer and no acceptance.
Okay, well, at this point, Your Honor, we're stating that we don't see the necessity of revoking his bond when we can take our plea and we can go ahead and move forward with the court's wishes. And this obviously will be a non-negotiated plea, but with some of the things in mind with the state wants.
At this time, Mr. Walker is going to be taken into custody. He'll be held in jail until such time as his case is resolved or he has a trial.
Well, we've said, Your Honor, we don't want a trial. So
I got you.
Does Your Honor have any sentiments with regards to what she will be issuing? Okay,
this is what was on the table, Mr. Middleton. You were supposed to go into the to the Clayton County DUI court. That was all. We gave you 2 weeks for that. Then you came back and said, well, we want to do Cobb. We gave you another month for that or more. Then, I'm done. I gave you the opportunity to go into Clayton County's court. You didn't want to do that. You went to Cobb because it was more convenient for Mr. Walker. They didn't want him. But Mr. Walker's not going to be just traipsing around outside. He's too much of a risk.
Okay. So, Your Honor, as I stated, we will take the sentence here and now and then allow him whatever the court wishes to do from here. To me would be the only logical thing at this time.
Mr. Middleton, I'm not prone to do DUI jail sentences for DUIs because most of the time it's a negotiated plea. But in this case, I don't think that Mr. Walker takes seriously enough what's going on. For you to come back to me and say, well, Mr. Walker didn't need treatment from Cobb, but you know his history. I don't think that that y'all are taking this seriously enough.
And that's what we're saying to the court now. And that's why we were prepared to come before the court. But however, that motion to revoke bond was filed immediately the same day when you sent us out to look at Kyle. In fact, I think it might have been filed before,
Okay.
if you look at the date.
Mr. Tipton, are you inclined to have to go forward with the plea today?
Your Honor, I'm forward with a non-negotiated today. I do want to just state that I believe would be inappropriate for Mr. Middleton to attempt to prod the court to see what the court is inclined to give Mr.
Oh, I wasn't inclined to tell him.
Thank you, Your Honor. State is inclined to do a non-negotiated plea.
All right, you can unhook Mr. Middleton Mr. Walker for now. Thank you.
I couldn't hear the last thing you said, Your Honor.
I said he could unhook Mr. Walker for now. Let's go ahead and get the plea set
Oh,
going.
okay, okay. So does the state want to put us in a breakout room so it can make that plea or what?
No, we're gonna do the plea on the record. Why would we be in a breakout room?
Oh, now what is he asking then? That's what so we'll be clear on what they're asking.
Well, in a non-negotiated plea, y'all come before me, you get the plea started, and then he will ask on the record during the plea colloquy what he wants. You will ask for what you want, and I'll make a decision.
Okay. So that maximum, where is he now? He's changed so many times.
Okay, you asked for a non-negotiated plea. Now you're asking for him to negotiate the plea.
Well, now I just was asking what he wanted. Because
Yep.
we had said several.
Okay, well, let me get started, and he's gonna tell you in a minute.
Okay,
Right.
great. Your Honor.
State of Georgia versus Willard Kirkland Walker, 2021 CR 08227. DUI less safe, count 1, striking a fixed object, count 2. Mr. Walker is represented by Mr. Nathaniel Middleton. Mr. Middleton is present by video. Mr. Walker's in court. The state is represented by Mr. William Tipton. Mr. Walker, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. You're before the court on State of Georgia versus Willard Walker for DUI less safe and striking a fixed object. Mr. Middleton, what does your client plead to the offenses before the court?
We plead guilty.
All right. By entering a plea of guilty to counts 1 and 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any evidence or testimony against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
Mr. Walker?
Yes.
All right, factual basis, please, and recommendation from the state, and then I'll hear the recommendation from the defense.
Yes, Your Honor. On May 22nd of 2020, Officer Santos with the Clayton County Police Department responded to a driver who hit a mailbox. It was determined the driver was the defendant before you, Mr. Walker. Mr. Walker hit the mailbox at that location belonging to a Miss Margaret, Margaret Sloan, Sloan, who attempted to make contact with Mr. Middleton. Upon arrival, the officer attempted to perform HGN. Mr. Middleton refused HGN. This is after seeing various clues that indicate intoxication, including slurred speech, red glassy eyes. Let's see. And the odor of alcohol. Upon making contact with Mr. Walker, Officer Santos requested HGN. Mr. Walker refused. Then he requested walk and turn. Mr. Walker refused. Then he requested one leg stand. Mr. Walker refused. Mr. Walker did not consent to implied consent. He was arrested for striking a fixed object, that being the mailbox belonging to Miss Sloan, and for DUI based on the totality of the circumstances. Your Honor, this is Mr. Walker's second DUI. He had a DUI subsequent to this, making it his third conviction over the course of the events took place over the course of 3 years. Out of Douglas County, out of Clayton County, 2021 out of Douglas County, out of Rockdale. Your Honor, state is requesting for count 1, 12 months to serve. State is requesting for count two, a consecutive 12 months of intensive probation. That would include all the regular DUI requirements. DUI risk reduction course, no drugs or alcohol, subject to random testing, substance abuse evaluation, and any recommended treatment. No less than two community support groups per week. 240 hours of community service, a $1,000 fine. Bi-weekly testing, every other week, that is. That the defendant's license be suspended during the entirety of his probation. Nothing further from the state, Your Honor.
All right, Mr. Middleton.
Yes, Your Honor. With regards to what the state wants, we are willing to accept all of the conditions with the exception of, as I stated, the 12 months to serve. Before, the state was only offering at first 2 days, then 10 days, then 30 days. I don't understand why they're fluctuating between the number of days to serve. You know, it's not consistent.
3 convictions in 3 years.
Well, those it's over 10 years. It was 2 and 5, and the other was beyond the 10, so that shouldn't count at all. But we are willing to accept what the state has to offer with the 2 and 5, and that's pretty fast, head fast to the law. But 12 months would not be it. I think 30 days would be appropriate at this time, Your Honor. And we would ask that if Ms. Walker could serve those on the weekend, because he just got a job and he's been unemployed since COVID. He's been trying to put ends together, and he's got a lot of bills. He doesn't have any kids, thank God. Right now his kids are grown, but we think that we can do 30 days and take those on the weekends, Your Honor, and pay a fine. We'll be willing to deal with that without any problem, Your Honor.
I'm sure, Mr. Middleton, but Mr. Walker has had 3 lifetime DUIs. So the first one, even though you said that's outside the point of consideration, that to me, a DUI should shake you up enough to say, I never want to go through this again. And I don't care what's going on in your life. Everybody has something every day. If you slung a cat at 6 people and hit them, you probably would not want their lives in exchange for what you got going on, because everybody's got something. So the excuse that he was going through this, he was going through that, he was going through this. If he had sat home and drank and never gotten behind the wheel of a car, it would not be my concern. I would wish him well. I would hope he would get some help, but that would not be my concern. But for some reason, Mr. Walker doesn't mind drinking and getting out on the road. And then 2 in a very close proximity in the 5 days. And then when I ask okay, I said, let's put you in DUI treatment court because that to me makes sense. You don't want to do the Clayton County Treatment Court because we want to be convenient for Mr. Walker. So, okay, I'm gonna let Mr. Walker do what's convenient because I feel like if you can get it to where it's easy for you to do, you will do it. Then y'all to go to Cobb, and for some reason, I don't know why, a previous lifetime DUI, this DUI, another DUI pending, they tell him that he doesn't need treatment. Now, I've never heard that. That to me is just crazy. But I don't, like I said, I don't know Cobb's metrics. I don't know what they do, what they measure. So now the ball's back in my court. Motion to revoke gets filed. I'm waiting to do the motion to revoke, waiting to do the motion to revoke. Okay, we're here before the court for the motion to revoke. And then I get, well, Judge, he's done all these things. Well, first of all of them are from 2022. So I'm sure they're associated with some other DUI or something else that doesn't concern me. And then I get information about he's done 240 hours of community service from an organization that he headed that doesn't even exist anymore. So I just feel like I'm ill-used in this situation. And I don't know that Mr. Walker is taking seriously what is going on because there's tons of people who go through tons of things and they don't have not one DUI. When you fail to acknowledge the fact that you have an addiction problem, because most people, they're used to seeing Otis the drunk from the Andy Griffith show, who comes and he's laying down on the floor and then he'll get up and go lock himself in the jail and sleep it off. You don't have to be falling down drunk and not able to function to have a problem with addiction. You do have to make very, very reckless and inconsiderate decisions around your addiction. And Mr. Walker has made reckless and inconsiderate decisions around his addiction. At some point, we have so much technology now and so many new things that we could do that are alternatives to getting behind the wheel under the influence. But somehow we're not getting that. Like, you don't have to drink and drive. You can stay home and drink, or you can have someone else drive you. And for very little money comparatively, because this is not the age where you would have to call a limousine if you wanted to have a night on the town or be chauffeured around. You can call an Uber. But Mr. Walker was willing to risk other people's lives repeatedly, 3 times that we know of in his lifetime, 2 in 5 years that we know of. He was willing to risk lives because he's making reckless decisions. And so I'm going to sentence Mr. Walker on count 1 to 12 months to serve 180 days in the Clayton County Jail. Balance will be probated for him to begin intensive probation, a risk reduction course, no alcohol or illicit drugs during the course of his probation. He's subject to random screens for alcohol and illicit drugs. He'll take a substance abuse evaluation and any treatment that is necessary. He'll do 2 community support meetings per week and report his attendance at those meetings. Those community support meetings must be for the cessation of addiction. 240 hours of community service, a $1,000 fine. He'll test at each report. Count 2 is 12 months to be served consecutively to complete the special conditions as ordered in count 1. And Mr. Walker will get an interlock device also. Once he gets his license back for the remainder of his probation.
So he will be eligible to get a permit, Your Honor?
If he, so what's Mr. Tipton, what's the suspension period for the for the DUI?
Your Honor, I believe that it's 180 days. If the court can give me a moment, I can confirm that.
Okay, and then after the suspension period is over, he'll be required to have an interlock device.
Yes, Your Honor.
And Your Honor, can he report at another date, not today?
Sure. What day would he like to report?
Your Honor, state would object to him. The state would object to him having a later report date.
Yeah, I mean, I agree with Mr. Tipton because y'all have been on the calendar for this for 5 months, 5 times. So if he hasn't gotten his stuff together in all of those times that y'all have been on the calendar for this, then it's just not. I mean, at least you should have anticipated something happening. So yeah, Mr. Mr. Walker will be taken into custody at this time. All right, Mr. Middleton, you'll get a copy of his sentencing sheet. Ms. Wright can send that to you. Ms. Wright, if you need his email address, I think Mr. Tipton and I both have it on an email.
And Your Honor, I would like to make sure that Mr. Walker is aware that if he has questions, he needs to talk to his attorney. He has attempted to speak to me just a moment.
Yeah, Mr. Walker, you can't speak to the state's attorney. He's not representing you. He's representing the state. If you need to talk to Mr. Middleton, he can come see you in lockup.
And for the record, Your Honor, may I say something?
Yes.
Yeah, if the Mr. Tipton would and if the court would go back and change some of the language that from the transcript, he called my name versus Mr. Walker's name.
I apologize for that. I'm looking at your name on the screen, and then all I see is state court OTD pod. So I was at all times when I intended information for the defendant, that was Mr. Walker. I apologize for saying Middleton, but I'm looking at the screen and his name is written out. And as I'm speaking, that is probably what I said. So my apologies.
Yes, that was also the state's intent, was to refer to the defendant as Mr. Walker each time it referred to the defendant. Once again, same situation with me and Judge Hayward. I've been looking at Mr. Middleton's name on the screen pretty much constantly during this hearing.
All right. So Mr. Walker can be taken into custody. Any questions he can ask his attorney. We'll get you a copy of the sentencing sheet.
Can I bring something else forward to the Honor?
Hold on. Don't take Mr. Walker back yet. Yes, Mr. Middleton.
Mr. Walker is on medication that he needs to take on a regular basis.
If you all provide the medication in the labeled prescription bottles and a copy of the prescription from his physician, Mr. Walker will be administered his prescriptions. You can provide it to the medical staff at the jail if you need an order from the court to allow them to give it to him. But generally, all they need is the prescription and the labeled bottle, the bottle labeled as it is as he purchases it.
If we can get that order, Your Honor, would save time, because I don't know I don't know exactly where. I've never been to his house, and I believe he lives alone.
Your Honor,
if somebody can provide his prescription, I mean, I can give a medical order that he's to get his medication as directed, but they do that anyway. But what I can't do is tell him what to give him, because I'm not a doctor. So he would need a copy of his prescriptions to be able to do that.
Yeah, I know, that's what I'm saying.
He has grown children, they can't get his medicine.
But he lives alone. But we can reach out to him. Is there any way we can have a breakout room with Mr. Walker after you get through?
No.
No. Okay, well, we'll try to do the best we can, Your Honor.
All right, thank you, Mr. Middleton. All right, let's go back
Excuse
to
me,
the,
Judge, I'm sorry. Did we get the clarification on the interlock device?
yes, he's going to have one. So I
That's
have,
not the clarification. You said that, there was some kind of, 180 days or something?
okay, so this is what I have on count one, 12 months to serve 180 days. The balance will be probated. The special conditions of probation are that he will do a risk reduction course, have no alcohol or illicit drugs during the course of probation, subject to random screens for alcohol and drugs, a substance abuse evaluation and any treatment as necessary, 2 community support meetings per week for the cessation of addiction, 40 hours of community service, a $1,000 fine, and he's to test at each report for alcohol and illicit substances. And after the service of his suspension with the Department of Driver Services, he'll have an interlock device for his vehicle. Count two will be consecutive 12 months of probation for him to complete all of the special conditions of probation.
Perhaps that was the question in the suspension of his license, because you said after the suspension, he would have the interlock.
He has to serve a 180-day suspension that's statutory with a DUI conviction.
Okay, that's what I needed to know. Thank you.
You're welcome. All right. So back to the arraignment calendar. Mr. Lynch, Ms. Tortorello, we ready to roll through that, please?
And Your Honor, do you want Mr. Walker to go back now?
Yes.
So may I be excused, Your Honor?
Yes, Mr. Middleton, thank you.
Thank you.
Your Honor, I have an announcement on behalf of Mr. Aquil. He's gonna go ahead and plead not guilty and waive formal arraignment.
All right, so all right, so sir, please remember what you are before the court on. You do have bond conditions that say that you're not to have additional violations of the law. But what happens generally is because people are trying to get their life together, when they have a driving on suspension or revoked license, then I see a subsequent driving on suspension or revoked license. So please, sir, remember that you already have this charge pending. If you get out there without your proper licensing and you get another charge, it will only make your problems worse. All right. So please keep in touch with your attorney. You're free to go at this time. You are waiving formal arraignment, Ms. Tortorello. So please make sure you keep in touch with the state so that you all can determine if this can be resolved prior to trial. All right, what's next?
Your Honor, Mr. Thorpe is ready to move forward with a negotiated plea.
All right, Mr. Thorpe, let me see you, hear you. Mr. Thorpe? All right, who's next?
Judge, Mr. Wallace, are you still on the non-jail calendar?
Yeah, I'm trying to get to the jail calendar.
Okay,
Hold on.
all right. Thank you, Judge.
Ms. Tortorello, who's next?
That's all I have, Your Honor. I think Mr. Thorpe was.
Okay, who's got Smith and Turner? Mr. Lynch, is he ready on Smith and Turner?
Judge, so for Ms. Turner, we're ready for a negotiated plea.
All right, Ms. Turner, turn your camera on, turn your audio on. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. So Ms. Turner, you're before the court for DUI count 1, DUI less safe count 2, improper lane change count 3, failure to dim headlights count 4. You're represented by the law firm of Lister, Holton, Dennis. Mr. Lynch is with you at the podium. I mean, he's in court with you. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, that's going to be a guilty plea to count 1 DUI per se. Count 2 should merge. Count 3 would like the court to accept a no-low plea, and count 4 will be a guilty plea.
All right, by entering a plea of guilty to counts 1 and 4, count 2 will merge. Count 3 will be a no-low plea. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up a right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any evidence or testimony against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right, factual basis recommendation, please.
Yes, Your Honor. Your Honor, on May 27th of 2023, officers with the Clayton County Police Department observed a vehicle driving with its high beams on within 500 feet of other vehicles. While attempting to pull the vehicle over, they observed an improper lane change. Upon making the stop, Your Honor, the officers involved did notice indicators of impairment, including the odor of an alcoholic beverage on the defendant's breath. And the defendant did admit margaritas, 2 Patron margaritas at a hookah bar. At that point, standardized field sobriety tests were conducted, leading to 6 out of 6 on HGN, 5 out of 8 on walk and turn, and 4 out of 4 on one-leg stand. Based on that, Your Honor, the defendant was asked to arrested for DUI alcohol. It was determined by a blood test that she was driving with a concentration of 0.150. This is the defendant's first in life DUI. State's recommendation is 12 months to serve 2 days, credit for time served, balance probated, a $300 fine, 40 hours of community service, DUI risk reduction course, no drugs or alcohol testing, substance abuse evaluation, any recommended treatment. Count 2 will merge into count 1. Count 3 will be a suspended fine of $100. Count 4 will be a suspended fine of $100. Nothing further from the state.
All right, Mr. Lynch.
Judge, that was my understanding of the recommendation, and I am asking that the court accept it. I did discuss the requirements of probation, specifically no alcohol. I think Ms. Turner will be able to get everything done. I've explained to her about affidavits of first conviction and application for a limited permit. Judge, this is her first in life DUI, and from speaking to her, I do not believe there's going to be another one. So we discussed the court.
Ms. Turner, I'm going to accept your plea of guilty to counts 1 and 4. Your NOLO plea to count 3. Count 2 will merge. I'll sentence you to 12 months to serve 2 days, credit for time served on count 1. Balance will be probated for you to pay a fine in the amount of $300. It's going to be closer to $700 or so because of the enhanced fines and surcharges for DUI. 40 hours of community service, a risk reduction course. You're to have no alcohol or illicit drugs during the course of your probation. You're subject to random screenings for alcohol and drugs. You'll take a substance abuse evaluation and any treatment that they order you to take. Count 3 will merge. Count 3 will be concurrent with count 1. It's a $100 fine suspended. As long as you do the requirements of count 1, you do not have to pay the $100 fine suspended. Count 4 will also run concurrent with count 1. As long as you do the requirements, the special conditions of count 1, you do not have to pay the fine, the $100 fine that will also be suspended. Ms. Turner, please let this be your only DUI. We got too much going on for you to put other people's lives at risk out of recklessness. And so please make sure that you comply with the requirements of probation. If you have issues, you need to talk to your probation officer because they're here to help you successfully complete probation. But the last thing you want to do is fail to show up for probation, because if you fail to report, then you will be before me on an arrest warrant. Okay, that is the quickest way to get rearrested. I'm going to put you in a breakout room with Miss James. Miss James is our probation expert. She's going to do your intake. She's going to answer any questions that you might have immediately about the requirements of probation, and she's going to direct you as to what you need to do next. Please make sure that you do everything that you're supposed to do on probation. And you do not have to come back to this main room. Once you have spoken to Miss James, you can go ahead and go on and get started with what you need to do, okay?
Okay, thank you.
All right, thank you, ma'am. All right, I'm gonna put you in breakout room number 6. All right, okay, Smith and Thorpe. I tried to call Mr. Thorpe because we were ready, but he's missing. What's going on with Smith?
Judge, for Ms. Smith, we are going to enter a not guilty plea today.
All
We
right.
will waive formal arraignment and we'll be in touch about potentially getting resolution.
All right, on Smith, just remind her, most people, when they got a driving on a suspended license, they go right out and get another one. So please be mindful of that, Ms. Smith, to not do that. You can go back with, you can go on and contact your attorney and keep in touch with them. I'll be right back.
Oh, and you're. Oh.
All right, jail calendar.
And Your Honor, if I may please the court, before you start the jail calendar, Mr. Thorpe is present. He's back on the call. So just wanted to let Your Honor know.
I'm ready. Mr. Thorpe. He never left the call. Ms. Smith, you have a question, ma'am?
Yeah, am I free to leave the call or?
Yes, ma'am.
Okay, have a good day, sorry.
No problem. Mr. Thorpe never left the call. He just won't respond.
I see, Your Honor. I didn't see him on my screen, but I see.
I see him. He just won't respond. All right, jail calendar. Barnes, Robert Barnes.
Your Honor, we would need to break out for that one. That's an MH case.
Okay. All right, Jamal Tayoun Brown.
Judge, that's going to be negotiated plea today.
All right, Romero Valleda Casar Noel, or Noel Romero Valleda Casar.
Yes, Judge, that'll be negotiated, please. Well, we work it
All
out.
right. Does Mr. Casar Noel need an interpreter?
He will not need an interpreter for this case, Judge.
All right, great.
Your
Yes.
Honor, the interpreter is here. Can she be excused then?
Okay, Miss, is it Miss Bermudez or Miss
Well-
Tolles? Yes.
Judge, if she's there, then we would like her to go forward, but based on the charges, I believe we can handle it without her. I just didn't think she was
Well,
there.
it's not based on the charges. It's based on his proficiency with English and whether he is going to understand all of the rights and responsibilities that come within taking a plea. So I'll ask the interpreter to remain, and we'll go ahead and do that as quickly as possible. Preston Kamei Collier.
Your Honor, we will need to conference regarding Mr. Collier's case. It's an MH matter.
All right. All right, Diggs, Tatiana, Titania Diggs.
Yes, Judge. Even though we're not listed as being appointed, she does wish us to be appointed on her case.
That's fine.
That is going to be a negotiated plea today.
All right. All right, petition Anthony James Hicks Jr.
Yes, Your Honor, we are stipulating to the probation violations only, not the new charge, and we would like to move forward non-negotiated before you, Your Honor.
Okay. Lewinsky Angelo Monesteem.
Good morning, Your Honor. Byron Morgan for Mr. Monestein. Mr. Tipton and I talked yesterday. He made me an offer. I need to communicate it to my client, which means I need a breakout room with my client.
All right, when he comes out, we'll give you that. Errol Raymond Jr.
Your Honor, I would need to speak with the state about his case. This may be resolved.
Jason Lynn Smiley.
Judge, Mr. Smiley, I believe, had an appearance in Judge Mack's court and is not yet here. As soon as he does get here, I will conference with him as expeditiously as possible.
All right, we've already done the Walker case. And LaShondra Denise Willis.
That's a negotiated plea, Your Honor.
All right, let's start with Kassar.
Your Honor, while they get Qatar. Brandon, you a fan of Shakespeare?
Sort of. I just think that the most appropriate line for what I do is methinks you don't protest too much.
I see. Well, I was asking because Miss Diggs's name is from a Shakespearean character.
Ah. 12th Night?
No,
Midsummer Night's Dream. Yeah, Midsummer Night's.
Titania, the fairy queen, the wife.
Yeah.
Mm-hmm.
And Puck.
Oh yes, Puck was one of my favorites. And of course, you said methinks thou doth protest too much. It immediately made me think of my favorite line from A Midsummer Night's Dream. I'm sure you remember that one. I can't say it on this Zoom call.
Yes. Good morning, Ms. Bermudez.
Your Honor, how are you?
I'm great. How are you?
I'm well, thank you.
All right. Mr. Kassar, you're before the court on State of Georgia versus Romero, Valleda, Kassar, Noel. Did I get that right?
What did you say again?
I said, is it Noel Romero? Is Noel your first name or is it your second last name?
¿Es Noel su primer nombre o es su segundo apellido?
Es bien, César Noel Romero, sí.
¿Es César?
César Noel Romero, sí.
Es César Noel Romero.
Valladares.
Valladares.
Oh, okay. They got it all mixed up.
O sea que lo tengo todo al revés.
Sí.
All right. So, Mr. Vallada, you're before the court for attempting violation and no license.
Polarizados y por no tener licencia de conducir. Acércate un poquito más al lado.
Your attorney, Mr. Mike Wallace, is here.
Mike Wallace está presente.
And Mr. Wallace, you can go ahead and speak. I don't know if he can see you.
Hello, can you see me now?
¿Puede usted verme? Le pregunto a su abogado.
Sí, yes.
Yes.
All right, so Mr. Vallada, you can raise your right hand for me.
Levanta su mano derecha para mí.
Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
Okay, you can put your hand down. Mr. Wallace, what does your client plead to the two offenses before the court?
And Your Honor, so the
Y su
court,
señoría,
so the court is aware
para que
the
la
state's
corte
only
sea
going
consciente,
forward on
el
the
Estado
tinting
solamente va a
violation.
proceder en el cargo de tener los cristales polarizados.
All right, to count one, count two will be no cost.
Uno y el cargo número 2 va a ser desestimado, siempre de frente a la justicia.
As to count one, Judge, my client is to plead guilty.
Es el cargo número 1 y mi cliente se va a declarar culpable.
By entering a plea of guilty, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt.
Razonable, siempre de frente a ella.
You
Yes.
give up the right to present, to have the presumption of innocence in your favor.
Por favor.
You give up the right to present evidence and testimony on your behalf,
Ser usados en su defensa.
to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. All right. Factual basis, I'm willing to stipulate if you are, Mr. Wallace.
We are, Your Honor.
Estoy de acuerdo en que no lo lean.
Recommendation, Mr. Tipton.
Recomendación, señor Tipton.
Yes, Your
Sí,
Honor.
su señoría.
Mr. Romero Valderas has
El
been
señor
arrested
Romero
twice for
Valderas
this
ha sido,
incident.
arrestado 2 veces por
He
este
has had a
incidente.
total of 42 days in the Clayton County
Y ha estado
Jail.
en la cárcel por un total de 42 días.
State's recommendation is
La
42 days
recomendación del Estado
to
son
serve
42 días para
credit for
servirlo.
time served.
Crédito por el tiempo ya servido.
Nothing further from the state,
Y
Your
no
Honor.
tengo nada más por parte.
First, let me apologize, Mr. Valladares, because that's ridiculous. I'm not sure what happened, and I'm not sure if this is connected to something else, but on behalf of the state court and my office, we don't really control how quickly you get to me, but I apologize. I'm gonna give you credit for time served on this. And also, I want to remind you that you paid a cash bond, possibly. I see that you have, it's a bondsman thing here. So I'm gonna ask you to make sure that you check before you leave the jail to see if there's any money that you are due from the bond.
And Your Honor, so the court is aware.
Yes.
Mr. Romero Valderas is currently being held on charges that I believe are in the Superior Court.
Okay. All right. But you still should have been in front of us quicker to get this resolved, and I apologize for that. All right, you're free to go at this time, Mr. Valladares. And I'm sorry because it cut off the last part of your name, but I see it on the where it has the bond.
I'm sorry, Your Honor. Just for the record, Mr. Valladares asked if he could plead nolo or something.
Well, Mr. Valladares, it's a tinting violation. If you may want to talk to your attorney about whether you need to do that. Mr. Wallace, did you want to answer his question?
Judge, we did have that discussion, and I thought we had decided on my conversation with him that he would not use the nolo contendere on the tinted window. And
now my understanding is if the other charges he faces that he may want to use it for, a tinted window violation is not in the same class of charges and it would still be available to him, but you're his attorney and that's between y'all. But I just wanted to make sure he was clear before he went back upstairs.
it's intentional that we not use it on this offense, Judge.
All right. So, Mr. Valladares, you have an attorney. He's advising you. Y'all make that decision together. And you're free to go at this time back to with the sheriff's office.
Your Honor, before we send him back, I did want to bring it to Mr. Wallace's attention. I've looked at the dates of the incidents that he's being held in on. It appears that if it's unclear whether or not state or superior court, or it should go state or superior court, but it's well past the statute of limitations for the state court. If Mr. Wallace would be kind send me an email about this case, I'll get on it immediately to see if it's one of the cases that will be coming to state court, and then get with Mr. Brooks to see how we could process them further. I think that this is a situation where, because the jail's not properly equipped for folks that are that primarily speak languages other than English, he may have fallen through the cracks, and I don't want him to be stuck in there on a case that he has every right to be out of.
All right.
Understood, Judge.
All right, so, yeah, speak to Mr. Tipton. If he can help you out on that, he will. So thank you, Mr. Wallace. You're free to go at this time, sir.
Thank you, Your Honor. Good to see you.
All right, good to see you.
Mr. Wells, I'm gonna send you my work cell real quick so you can contact me, okay?
Okay, can you put it in the chat?
Yeah, he's gonna put it in the chat, so just write it down before you leave. All right, so Brown, are we ready on Brown?
Yes.
Thank you, Ms. Bermudez. You too.
Thank you. And Your Honor, at this time, we have no further victim cases. May Ms. Hemphill be excused?
Yes.
Thank you.
Thank you, Ms. Hemphill.
Yes, ma'am. Thank you.
All right, Mr. Brown, raise your right hand for me. Solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
Okay, you can put your hand down. So, Mr. Brown, Jamal Tayyoun Brown, 2025 CR 05994 for criminal trespass. Mr. Brown, you're represented by attorney Owen Lynch with Lister, Holt, and Dennis. Mr. Lynch, what does Mr. Brown plead to the offense before the court?
You can ask the court to accept a no contest plea in this matter, Your Honor.
All right, any concerns?
Judge, no, at this point, although there are mental health issues at play, my client has indicated he is taking medication. He does understand the basis for the charges and the significance of what he's doing here today. I appreciate the court for continuing this case and giving me the chance to talk to Mr. Brown further, but at this point, I believe he's competent to enter a plea of no contest in this matter, Judge.
All right, and Mr. Brown, how old are you, sir?
26.
Okay, so by entering a plea of nolo to criminal trespass, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the presumption of innocence in your favor. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself or present evidence and testimony against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis recommendation.
Yes, Your Honor. On May 29th of 2025, officers with the Clayton County Police Department were called to the McDonald's located at 7894 Terra Boulevard in response to a disturbance. it was determined the defendant before you, Mr. Brown, did attempt to enter the property and asked to leave, but refused when office came and asked him to leave. He refused. State's recommendation, Your Honor, is 12 months to serve 41 days, credit for time served, balance suspended upon do not return to the incident location. That is the McDonald's located at 7894 Terra Boulevard in Jonesboro. Nothing further from the state.
Thank you, Judge. And that was what we had anticipated, and we'll ask the court to accept that at this time.
All right, so Mr. Brown, I'm going to accept your plea of NOLO, 12 months to serve 21 days, balance suspended, as long as you do not go back to the McDonald's at 7894 Terra Boulevard, Jonesboro, Georgia, Clayton County.
Okay, Your Honor.
Right, sir. Take care of yourself, Mr. Brown. Take your medicines and so you can stay well, okay?
Okay.
Hey, Your Honor, if you don't mind, I speak real quick.
And you are?
Thorpe.
You are who?
Thorpe. Shamar Thorpe.
All right, Mr. Thorpe, I called you like 4 times and you didn't appear, so I'm gonna need you to hold on because I'm in the middle of something else.
Okay, my bad, because I was my phone, like, you know, I'm on Zoom on my phone, it was acting up, so I was just trying to communicate, let you know that I'm here this time. So
All right, thank
I'm
you.
still here.
All right, who's next?
You got one here. Keep going. Judge, we can do Miss Diggs next. Yes, she's a female. They'll have to process them out in a he's not held on Stand right next to me, right on our right side, okay?
All right, Miss Diggs, raise your right hand for me. Ms. Diggs, do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court. Tanya Deneen Diggs, 20.
Judge, we can't hear you. I didn't hear you.
Tanya Deneen Diggs. You hear me now?
Yes, ma'am. I didn't get the complete case number.
Oh, I hadn't started it yet. I was trying to find it. I messed up something on my screen. 2025 CR 07896 for criminal trespass. Mr. Owen Lynch is representing Ms. Diggs. Ms. Diggs is before the court. Mr. Lynch, what is she pleading to criminal trespass?
Judge, we'll ask the court to accept the no contest plea.
All right, any concerns?
No, Judge.
All right, so Ms. Diggs, by entering a plea of NOLO, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present evidence, testimony on your behalf, not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. On July 24th of 2025, officers at the Clayton County Police Department responded to an incident at Stay Inn Suites, that's in with 2 N's, at 74 Davidson, in a portion of Stockbridge that is within the boundaries of Clayton County. The defendant before you, Ms. Diggs, was banging on doors and screaming into tenants' room doors. She appeared frantic when officers approached, and had previously been told to depart the location but refused. The state's recommendation, Your Honor, is 12 months to serve 32 days, credit for time served, balance probated upon do not return to the incident location. Once again, that is the Stay Inn Suites at 7465 Davidson Parkway in Stockbridge, Georgia. Nothing further from the state.
Mr. Lynch?
Yes, Judge. We would ask the court to accept the plea as negotiated.
All right, Ms. Diggs, ma'am, if you need any assistance when you're released from jail, please ask to speak to a chaplain, and they may have information to assist you with housing, with food, with anything that you need to transition back out. So I'm going to accept your plea of nolo, send you to 12 months to serve 32 days, credit for time served, balance will be suspended as long as you do not go back to the Stay Inn Suites at 7465 Davidson Parkway, Stockbridge, Georgia, in Clayton County. All right?
Yes, ma'am.
All right. Thank you, Ms. Diggs. Take care of yourself, ma'am. All right, who's next? Can we do Mr. Thorpe now? Where's Miss Tortorella?
She just disappeared.
All right. Who's next on the jail calendar? Willis?
Yes, we can do that. Yeah. You're gonna stand right here, actually.
All right, Ms. Willis, you're before the court. Lashandra Denise Willis, 2025 CR 07789 for criminal trespass. You're represented by Attorney Owen Lynch, who's with you. Ms. Willis, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
Okay, I'm sorry, I didn't hear you.
Yes.
All right, so Ms. Willis, you're charged with criminal trespass. Ms. Tortorella, what does your client plead to the offense before the court?
That would be a nolo plea, Your Honor.
All right, by entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Ms. Willis?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. On June 12th of 2025, officers with the Riverdale Police Department were responding to a report of suspicious persons at 6848 Sandy Creek Drive in the city of Riverdale, in a portion of Riverdale that is within Clayton County. It was determined that several people were occupying a foreclosed residence.
All right.
Yes, Your Honor. And the recommendation is 12 months to serve 30 days, credit for time served, balance suspended upon do not return to the incident location.
All right, Ms. Tortorello, anything else?
Yes, Your Honor. If my client can be escorted by a police officer to go back to the location only to get her belongings.
Okay, is it was she staying there with someone, or is it a vacant place?
My understanding, Your Honor, was a residence, and she was given permission by the owner to stay there. But she's left her belongings there, and she would need to go back to retrieve those if possible with an escort.
Okay, they won't go into a place that's not occupied or somebody's not responsible to be there. So she's got to make the appointment with through the sheriff's office with somebody who's responsible to be at the location.
Okay.
All right. So, ma'am, I'll send you 12 months to serve 30 days, credit for time served. You're not to go back to 6848 Vanity Creek Drive, Riverdale, Georgia, Clayton County, with but you will have one opportunity to go back with a sheriff's escort. You will make the appointment through the sheriff's office, and just make sure that you are able to carry away anything that you need that is your undisputed personal property. They're not going to carry anything. They're not going to transport anything. They're just there to keep the peace. Okay.
Okay.
All right. Thank you. You're free to go back with the sheriff's office at this time. All right. So Mr. Morgan needs to speak to his client. We are ready on Hicks, which is a petition. You still need to conference on Barnes and Collier and Raymond. Now, when you say conference, are you conferencing with Mr. Tipton or with the client? I'm asking a question. Can y'all hear me?
I'm sorry, Judge, was that directed to me?
No, it's directed to the people in the courtroom. So I'll know what do I need to do next. So we need conferences on Barnes, Collier, and Raymond. If y'all are conferencing, are y'all doing that now with Mr. Tipton, or y'all conferencing with your people?
For Barnes and Collier, Your Honor, that conference would be with you, just to give you an update on those cases. They're MH cases, and I would not like to make those.
Okay, I got you. So we'll do that at the end. For Raymond, what's going on with Raymond?
Raymond, I still need to speak with the state, Your Honor.
Well, he's right behind you.
Mr. Raymond?
No, Mr. Tipton. You said I still need to speak.
Yes, I would. I'm sorry. Yes, Your Honor. Yes, I would need to speak with the state. I was talking to Mr. Collier. That's why I have not been able.
Oh, okay. I was like, okay. All right. So what I'm going to do is I'm going to give Mr. Let's do Hicks, and then that'll relieve the probation office to go back to doing something else. And then we'll put Mr. Morgan and in a breakout room with the courtroom, so you can bring out Monestein. He can speak to him quickly, and then we can go back to do the remaining people. Okay. All right. So Hicks. All right, Mr. Hicks, one moment. Raise your right hand for me. All right, y'all, the courtroom's frozen. Can y'all hear me?
Yes, Your Honor, we can hear you.
All right, so Mr. Hicks, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, 1 second. All right, so you can put your hand out. Mr. Hicks, you're before the court on a petition for revocation of probation, State of Georgia versus Anthony James Hicks Jr., 2021 CR 08241 for simple battery family violence on the 21st day of April 2025. You were sentenced to 12 months on probation. You have 7 months and 24 days remaining because, and it says that you have had a new violation of the law, criminal trespass, battery, obstructing an emergency telephone call, and possession of marijuana 1 ounce or less on August 14, 2025. You failed to report on June 15, 2025 and July 15, 2025. You last reported on August 14, 2025. You failed to comply with counseling. You have not documented proof of enrolling in and or completing an anger management program, and you failed to pay. You are currently $200 in arrears. All right, you're represented by Attorney Tortorello. Ms. Tortorello, you all, is my understanding, are stipulating to the technical violations.
Yes, Your Honor, we're not stipulating to the new charges.
But you're stipulating that he was in fact arrested for new charges.
Yes, Your Honor. And we are asking, probation offers 120 days. We are asking for 60 days, Your Honor.
All right, so the new, for the new charges that involve battery and criminal trespass, who's the alleged victim on those new charges? And is it the same person as the underlying charges?
No, it's the different.
Ms. Chang?
Your Honor, good morning. Good afternoon. The original order from April 21st does not indicate a victim, and I don't have any information at the charge on who the victim may be. I don't know if the Mr. Tipton has more information.
Mr. Tipton?
Your Honor, I'm looking that information up now. Your Honor, it's a different victim. The victim on the first case is a Miss Deshanae, Shonae, and in the new case, I believe that it's Jasmine, Jasmine Johnson, Johnsson.
All right. All right. What's your recommendation, Ms. Chang?
Your Honor, probation recommends that probation be revoked to serve 120 days. Thereafter, suspend the balance and close the case.
All right, Ms. Tortorello?
Yes, Your Honor. Again, we're asking for 60 days to be revoked, and then from that point on, credit for the time he's already served in jail, and then the balance suspended and then case closed.
Okay, he didn't do his anger management and he picked up the same charges. All right, 120 days will be revoked, and the case will suspend and terminate upon the suspension.
Your Honor, my client, hold on.
Okay, don't tell me he about to have a new baby as a mitigating factor, because that will not be, in fact, a mitigating factor.
That wasn't gonna be my announcement, Your Honor. Nothing further from the state, Your Honor. I mean, from the defense, I'm sorry.
All right, so Mr. Hicks, you're going to serve 120 days revocation in the Clayton County Jail upon service of the revocation with credit since lockup. Your case shall suspend and then close. This is on the 26th day of August. All right. All right, you can go back with the sheriff's office.
Thank you, Your Honor.
All right. All right. So y'all have already been talking. Mr. Morgan, I guess, needs to talk to his client. I'm gonna put you in a breakout room, but let's not take all day.
Hey,
All right.
Judge, and I've learned that whenever I get one of these situations, I'll just go to the courtroom from now on.
All right, no problem. All right, so courtroom is in breakout room number 3. Mr. Morgan is being placed in breakout room number 3. Y'all can continue to conference as necessary, and when we come back, I'll expect an announcement.
And Your Honor, if
Yes.
Mr. Thorpe is still on the line, my apologies, Your Honor.
Okay. I'll called Mr. Thorpe again, and you were out of the room. So as soon as we come back in, we'll get Mr. Thorpe and we'll finish up the calendar. We have Barnes and Collier, Montestein and Raymond and Smiley. If he's not here, then he'll be moved to the next calendar.
And Your Honor, may I be excused?
Yes, ma'am, Ms. Chang. Thank you.
Thank you, Your Honor.
Deputy, you can go into the breakout room with Mr. Morgan.
And Your Honor and Mr. Morgan, I'm going to be stepping out of the courtroom. I'm packing all my stuff up now, just so that he can have some degree of confidentiality. I'll be back at my office though on Zoom.
Sounds good. Thank you. Deputy? Oh, yeah, it should be breakout room number 3, I think.
Yes, ma'am. I'm waiting. I don't see it yet. Hold on.
It popped up earlier. Hold on. I'm gonna move you. Don't do anything until I say so, okay?
Okay.
All right, don't do anything yet. Now, do you see it?
Yes, ma'am.
Hold on, wait. Wrong one. Do you see it now?
Yes, ma'am.
Okay, go ahead.
Judge, that's going to be a negotiated plea with Mr. Monestein.
All right, Mr. Tipton, you ready?
He left the courtroom, remember? He's headed back to his office. I don't think he's on yet.
Okay.
Judge, if you could give me just a second, I need to make sure nobody interrupts us anyway. Thank you.
Okay. I'm sorry, Miss Amanda. I think I like to think everybody moves at the speed of light. Let me just give him a moment to get signed in.
He is pretty fast, especially when he speaks.
There he is. Mr. Tipton, you ready? Mr. Tipton, I'm ready whenever you are. All right, there you are.
One moment, Your
So-
Honor, I'm having some issues with my audio.
I'm sorry, Your Honor.
Okay, you ready, Mr. Tipton?
One moment, Your Honor, I just had some issues with my audio.
Your audio sounds fine.
Yeah, I wasn't hearing you for a while.
Oh, I hear you.
I got you. No, but I didn't hear you for a second.
Oh,
So,
can you hear me?
It just whenever I got to my docking station, for whatever reason, it muted everything and I had to unmute it in a few different places.
Okay.
Okay. Mr. Morgan, can you refresh my recollection on what your client's last name is?
Monestein, Monestime.
Oh, Lewinsky, that's right. Okay, I'm ready, Your Honor.
All right. Mr. Monestein, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down, sir. You're represented by Attorney Byron Morgan. He's here with you during this hearing. You're before the court on 2022 CR 01870. Lewinsky Angelo Monestein for improper lane change, count 1, striking a fixed object, count 2, too fast for conditions, count 3. Mr. Morgan, what does your client plead to the offenses before the court?
He pleads to count 2, striking a fixed object. He pleads nolo.
All right, by entering a plea of nolo to count 2, counts 1 and 3 will be null prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the presumption of innocence in your favor. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself, or if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes,
Judge, we'll stipulate a factual basis.
That's fine with me. Recommendation.
Your Honor, count 2 will be a suspended fine of $300. That's suspended time that Mr. Monestein has spent in jail. I believe he spent 10 days in jail.
All right. So, Mr. Monestein, I'm going to accept your plea of NOLO to count 2. The $300 fine will be suspended for credit for time served. And you can go back with the sheriff's office.
Thank you, Judge.
All right, thank you, Mr. Morgan.
Yes, may I be excused, Your Honor?
Yes, sir.
Thank you.
All right, so I guess we have Smiley, who hasn't come back from Judge Max, Raymond, Collier, and Barnes, and I believe you all wanted a conference with the court for Collier and Barnes.
Judge, I'll let Ms. Tortorella speak on Barnes. However, for Mr. Collier, we do intend to enter into what I believe will be a negotiated plea. There are some things I want to put on the record due to the status of the evaluation and the report.
So are we doing that today?
Yes, I would like to do a plea.
Well, let's go ahead and do Mr. Thorpe, and after we do Thorpe, we'll do Collier, and then what's going on with Raymond and Barnes?
Mr. Raymond, Your Honor, I'm still negotiating with the state, and for Barnes is one that we need to talk about.
Okay, so Thorpe, Mr. Thorpe, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, so you're before the court on State of Georgia versus Jameer Thorpe 2024 CR 04235 for simple battery. You're represented by attorney MJ Tortorello. Ms. Tortorello, what is your client plea to the offense before the court?
For the simple battery, Your Honor, that would be reduced to a disorderly conduct county, and that would be a NOLO plea.
All right, by entering a plea of NOLO to the amended charge of county disorderly, you give up the right to have a trial by jury or a judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things?
Yes, Your Honor.
All right, factual basis recommendation, please.
Yes, Your Honor. On February 17th of 2023, officers with the Clayton County Public School Police Department responded to a brawl, as it was stated, or as it was referred to in the at Lovejoy High School. It was determined that no less than 5 students had participated in the school brawl, including the defendant before you, Mr. Thorpe. Mr. Thorpe had specifically made contact of an insulting, provoking nature with Mr. Christopher Wakefield. That's Wakefield Jr. By kicking him. State has reduced this to a county facts of the case. Once again, it's the equivalent of a schoolyard brawl, and Mr. Thorpe is Mr. Thorpe's attorney has done a lot of legwork with confirming that Mr. Thorpe is attempting to go to the military and has made some strides to clean his act up. So for that reason, the state has decided to reduce this to a county disorderly conduct. The state's recommendation is 6 months, serve 5 days, credit for time served, balance suspended upon no contact whatsoever, directly or indirectly, with Christopher Wakefield Jr.
All right, Mr. Thorpe, do you have any reason to see Christopher Wakefield Jr.?
No, we been fell out. Like we haven't talked since that day, and we ain't gonna ever talk. So
that's fine. So I'm going to accept your plea to the amended charge of county disorderly. I'll order you to 6 months, 5 days, credit for time served, balance suspended as long as you have no contact with Christopher Wakefield Jr. during the 6 month period of time. All right, Mr. Thorpe. Yes.
Your Honor, if I may request the court specifically go into the no contact provision, that includes any type of social media. If Mr. Wakefield posts anything about Mr. Thorpe, he needs to ignore it. If Mr. Thorpe is tagged in anything with Mr. Wakefield, he needs to find a way to get untagged. And it would probably be in Mr. Thorpe's best interest to block Mr. Wakefield on all social media and not have any interaction through third parties on social media, given his age.
Can I say something?
Yes.
When I say that we have fell out that day, that's what I meant. Like we don't contact nothing. Like we ain't in contact. We don't speak. We don't do nothing. Like we haven't seen each other. We haven't spoke on social media, and we ain't gonna ever do that. So. And I ain't gotta worry about none of that. So he's already blocked on social media.
It's our responsibility to let you know, Mr. Thorpe. What I want you to do is go to the military and take advantage of every opportunity that you have. Opportunities for education, opportunities for training, opportunities to get a skill set that will serve you once you come out of the military, or if you decide to make the military your life's work. Okay?
Yes, ma'am.
All right. Learn something, grow, travel the world. Do some interesting things. You hear me?
Yes, ma'am.
Come out, get post certified, work for a prosecutor's office as an investigator.
Yeah, they always recruiting, Mr. Thorpe. You go do what you want to do. All right. So we need a conference for Barnes. We're ready to go on Collier, and we need a conference. You still talking arraignment is what I'm understanding.
Yes, Your Honor.
All right, we ready on Collier?
Yes, Judge.
All right, Mr. Thorpe, you're free to go. Thank you, sir.
Do I get documents and paper mailed to my house?
You can get what you need to do is chat your email address to Miss Amanda Wright, RYTE. So when you do the chat, when you pull it down, her first name is Amanda, so she should be at the top of the list. You see her?
Yes.
All right. Send her your email address, and she will send you, make sure you check it and everything's right. She'll send you the sentencing sheet so that you will have anything you need for your enlistment.
And Your Honor, if I may, Miss Wright, if you could please let Mr. Thorpe know the process of getting a certified document from the clerk's office, since he may need a stamped and certified copy for his military career. I just know that's been an issue previously, so if you could chat him that information, I'd really appreciate it.
Okay, thank you.
All right. We ready on Collier?
Yes, Judge. I have Mr. Collier with me. Before we go forward with our plea that we've discussed, I did want to put a few things on the record just in terms of the status of the mental health evaluation and 90-day stay that we requested in light of us asking the court to take a plea in this matter.
All right, go ahead.
So initially upon contact with Mr.
Okay, this is case 2025 CR 02491 Preston Kamei Collier. Go ahead, Mr. Lynch.
Judge, so initially then a short amount of time from arraignment with Mr. Collier, we did request a mental health evaluation for Mr. Collier. And the initial finding of that evaluation was that Mr. Collier was not competent, but restorable. Since that time, we did request a 90-day stay to attempt to restore Mr. Collier to competency. However, and he is still pending bed space at Southern Regional or wherever Department of Behavioral Health would place him. However, since that time, I have spoken to Mr. Collier on several occasions, and he relayed to me today that he has been taking medication in jail. I independently verified that through Mr. Moore. We did contact the jail, and they indicated that he has been largely compliant with medication. I did speak to Mr. Collier about the facts of his case today and the legal significance of entering a plea. I do believe that Mr. Collier is competent to enter a plea. We are going to ask the court to accept no contest pleas. And so I guess that's what I need to put on the record at this point. If the state has anything they wish to place in the record in regards to that, or
Yes,
our position is we're ready to go forward with the plea.
the state will object to a nolo contendere plea on the theft by shoplifting case due to how they stack, excuse me. Mr. Lynch, I don't know if you've seen your cell phone also, but I am going to dismiss the obstruction of officer during this plea, and that's going to be whether you plead guilt, and that's going to be regardless of how the judge rules on action to plea.
Yes, and Your Honor, I do understand that the state is objecting to the nolo plea on the shoplifting, and that is his position. We are going to ask the court to accept it, but I understand I understand the significance of that. I am going to ask the court to accept the nolo plea on the shoplifting, however.
Your Honor, may I testify?
Hold on, Mr. Collier. You don't really have to testify if it's really about whether you're willing to enter a plea today to the theft by shoplifting and the simple battery. So Mr. Lynch, your attorney, has been talking to Mr. Tipton, the attorney for the state. I would not like you to say too much because they've already gotten rid of one charge. So I don't want you to say anything that might bring up other charges or bring back that charge, okay?
It's very important.
So Mr. Lynch, what store was this?
It's a gas station / convenience store, Judge. Let me give you the actual name.
Your Honor, I tap paid.
Yes, and he did.
At 9:48 p.m. Eastern Standard Time on phone number 470-495.
Okay, don't give me your whole number, Mr. Collier. I don't want anybody to steal your information. So Mr. Collier believes he tap paid?
Yes, Judge, that is referenced in the police report that Mr. Collier tried to make an attempt to pay. Obviously, there were, and if Mr. Tipton gets into the facts, if you do take a plea, that will be.
All right, well, I'll accept the NOLO on count 2. And did you want a NOLO on count 3 also?
Asking the court for that, Judge, but I understand it's in your discretion.
All right, so Mr. Collier, raise your right hand for me.
Your Honor, I did
Hold
not. I didn't.
Okay, I got you. I'm fine with
I didn't
that.
pour coffee on the officer.
I got you. That's why it's a NOLO, sir. It means that we know what they're saying, but you're not agreeing to that.
Yes, ma'am.
Okay, you want to raise your right hand for me?
Did I go home today?
If there's nothing else holding you, yes, sir.
Thank you. My right hand is raised.
Okay, do you swear or affirm any testimony you give will be true?
Yes, ma'am, Your Honor.
Okay, you can put your hand down. So, Mr. Collier, by entering a plea of NOLO to counts 2 and 3, count 1 will be no prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Collier?
Yes, ma'am. Am I going home today?
Yes, sir. I believe so.
Okay, thank you.
You're welcome.
I'm curious about what this gentleman over here said.
Hey,
That's okay. I got you. We're trying to parse it out so that we make it clear to you. But if we're able to get through this, then my understanding is that you can go home today because there's nothing else pending.
Thank you. I've been here 191 days.
Thank you, sir.
I got you. So, recommendation and factual basis recommendation, please.
Yes, Your Honor. Your Honor, on February 17th of 2025, officers with the Forest Park Police Department were called to the Texaco located at 4962 Jonesboro Road in reference to a suspicious male who they gave a description of, who had apparently left all points of sale while still with some Modelo's beer, a bag of Doritos, a Fanta, a five pack of cigars, a five pack honey backwood, and a pack of Camel cigarettes. Upon making contact with the defendant.
You said February 25th. It happened on the 16th.
I'm sorry, February 2nd, excuse me, 2025.
All right.
Okay, I'm sorry. My apologies, just correcting that for the defendant.
Mhm.
Upon making contact with the defendant, they searched him and found the merchandise that was stolen. During the arrest, the defendant did resist arrest, and in resisting arrest, he threw a cup of hot coffee on Officer Daz. That's Officer DAS of the police department. State's recommendation, Your Honor, is for count 2 and 3. That will be 189 days to serve, credit for time served, balance suspended upon do not return to the Texaco located at 4962 Jonesboro Road in Forest Park.
All right. So, Mr. Collier, I'm going to accept your plea of no load to counts 2 and 3. Count 1 will be no pros. I'll give you credit for 189 days served. Balance will be suspended as long as you do not go back to the Texaco at 4962 Jonesboro Road, Clayton County. Okay? And
Thank you,
should be
Judge.
going home today. Thank you.
I go home today?
Yes, you.
Yes, sir.
Thank you, Your Honor.
You're welcome.
It's been a nightmare.
I can imagine, sir. All right. Did Mr. Smiley ever come down?
Judge, we, according to Judge Max, I mean,
All
I'm
right,
sorry.
so
according to
we'll
Deputy.
continue Smiley until next week's calendar. And then let's talk about Raymond and Barnes. What's going on? Do we need a breakout room?
Yes, Your Honor, we could break out for Mr. Barnes' case.
Okay, what's going on with Raymond?
Raymond, I'm negotiating right now with the state.
Okay, we've been here 3 hours, Ms. Tortorello.
I've
Are
been
we
going back and
gonna
forth.
wrap up Raymond today, or is that something that needs to be continued?
Well, I have.
Your Honor, that's my fault. I've been unavailable during these hearings. I've been going back and forth. That's my fault.
Okay, all right. I'm gonna do the breakout room. The state court is in pod number 3. So if the state court pod will go into breakout room number 3, and then I'll meet you there. And I'll add Mr. Tipton, right? Do you need Mr. Tipton, right? Putting you in breakout 3.
Mr. Lynch, do you have a quick second?
I do. Do you want to call me on my phone? I can step out in the hall.
Yeah, I'll call you real quick.
All right, I'll be out in the hall.
You want them in there?
Judge, how are we doing with your son's quest for reading?
He's doing really well. He actually scored really well on the MAP test. He got in the distinguished category. So we're doing really well with that.
I'm glad to hear it. I just, I was hoping that he found something that he could really dig his teeth into.
Yeah, I mean, I don't know that he's gonna love it like I love it, but he's going to. He likes it enough to where he's good at it, But as a only child, for as long as I was, that was my big thing. For him, his big thing is basketball. So, he likes to read, but basketball is everything.
I can respect that. Have you ever thought about getting him a biography by one of the ball players?
Actually, he's read some. He picked one out himself when they had the reading fair. So I'm trying to remember which one it was, but he got his own. So he's chosen them himself.
Okay. You know what else might be good for him? Just because I know a lot of athletes love this, The Art of War by Sun Tzu.
I actually read that in college, and I will probably get that for him. He's 12 now, so I don't know that he'll appreciate it as much as he probably will in a little bit later.
Okay, I thought he was 14, so I was like, yeah, I was thinking that'd be good for him. But I don't know. I love to, I'm a bibliophile, so I appreciate it. I appreciate it.
A lot of good lessons in that book, and it's not a very big book, but a lot of great lessons. So
Yeah, it's only like 78 pages, and it's written almost poetically.
yeah. So.
Mm-hmm. Oh goodness, but no, it was just something I was curious about.
Oh, no problem. Yeah, he's doing really well, and so I was really happy about that. So he did well on his math testing for math and reading. So I was proud.
Well, that's great. I'm glad he's doing well. I always tell people you get people hooked while they're young on reading.
Oh yeah, definitely.
Yeah, because if they don't, I mean, I was so busy. Like I told somebody this a while back. I said when I got this job for the first time, I couldn't do any fun reading, so I was sweating and stressing. I needed my fix.
I know that's the thing. We read a lot for work, but it's not the fun stuff. So you got to carve out time to read the fun stuff.
Yeah, I recently got a book I'm really excited about. I've heard really good things about this author, so I was gonna try and crack it this weekend, but just didn't have time.
Yeah.
Oh, goodness. And I'm gonna prepare this null pros and have it sent to you momentarily.
All right, thank you.
You're welcome.
We ready? All right, Raymond.
I'm just going to wait for my client to come out to the court with an announcement, Your Honor.
Okay, we going forward on a plea or is this something else?
It was going to be a not guilty plea and we're going to waive formal arraignment. However, my client is being held on FDA. He has proof that he was at Grady Hospital because he has a sickle cell. There was a letter filed before the state court clerk's office, a letter from Grady Hospital stating, and of course, if the court could have judicial notice on this, this was filed on August 18th of 2020.
Okay, Mr. Tipton, do you have any objection?
Your Honor, I was unaware of the letter. If I may have one moment to review it in the clerk's file.
All
But
right, y'all been back and forth, back and forth. None of this you didn't give any of this to him?
Your Honor, I did not give this to him. I was waiting to hear back from my client to see whether or not he wanted to take a plea. But this was already filed. This was filed back on August 18th.
All right, what you asking me for, counselor?
I'm asking if the warrant, the FTA that's holding him can be removed so that he can be released.
Do you have his address?
Yes, his parents are here, Your Honor. They're here for his support. If you can stand up, please.
Okay, I just need to know that we can reach him. If he has an FTA, that means that the notice didn't get to him. If the notice didn't, I'm sorry?
He was in the hospital. He was at Grady Hospital.
Okay, well, as long as we have the right address, I'm fine with that. Bench warrant set aside, not guilty plea, good to go.
Thank you, Your Honor.
Know when you won, Ms. Tortorello. Sometimes it's easier than you're making it. All right, thank y'all.
Thank you, Your Honor.
I'll sign it when I get it.